Good morning, everyone. This is David Groth-Klaus. We'll give folks just 1 second here to join and then we'll start. Are you ready? All right. Thank you for joining us today. This is the Dorsey and Whitney annual training regarding municipal securities disclosure. In just a moment, I'll introduce the other speakers. But first, some housekeeping items. So this webinar is available for CLEs, continuing legal education for some attorneys. You see there on your screen the states for which we are expected to receive CLE credits. The program will be about 60 minutes today. We do have a fair amount of ground we're going to try to cover. And to the extent you have any questions, please email James Smith. There you see his email on the screen at smith.james@dorsey.com. Online attendance form for your verification for attendance today. Please scan the QR code on the slide next to the form. You must complete the form to receive CLE credit and a certificate of attendance. We will announce a code during the session. Please write it down as it will be required to complete the attendance form. We also have a download for the materials. You'll see there on your screen at events@dorsey.com. Let me introduce our speakers. To my right, joining us this year for the first time, I believe, is the Christina Kuhn. On my far right, James Smith, and to my left, Jennifer Block. This is the group of folks that probably many of you have walked through due diligence, continuing disclosure issues, and other disclosures with over the many years here at Dorsey. The agenda today, first we're going to answer why we're here, or attempt to answer that. Next, we'll be discussing disclosure as an overview, policies and procedures with respect to continuing disclosure. We do welcome questions. We'll try to provide answers. Please send your questions, as we said, to Mr. Smith. We'll try to tackle those as we go through the program. Obviously, we appreciate the more questions we think, the better this program will be. And then just for your following along, the appendix begins on page 47 of the materials that were sent. With that, I will turn it over.
Ready to go with the very important question of why are we here, which is, what I think about every day. Why am I here? But why we're here with this continuing disclosure presentation. In this section, we're going to do a brief federal regulatory framework overview, a little bit about Security and Exchange Commission enforcement actions. We all talk about as SEC, a little bit of guidance on public statements and some SEC trends. The why we are here, how we got here, a lot of this is because at some point, for those of you listening, and a lot of the people that have signed up are governmental issuers. There's a few out there that are conduit borrowers. Also borrowing on municipal securities, borrowing money through municipal securities, either on a taxable or tax exempt basis. We also have a few of our friendly underwriters as well as municipal advisors on the phone. But because of the involvement in borrowing money through municipal securities out in the open market, you had an official statement. As I brought props, right? Because we're now on video, we brought props. An official statement. You also were required to sign a continuing disclosure agreement or certificate in which agreed to provide ongoing continuing disclosure. And part of that policy required annual training. So many of you are here for that annual training and satisfying that requirement. It sort of gets to why we're here, other than somebody in your finance department said show up. One of us said show up, your friendly underwriter or municipal advisor said show up, and to check that off the list. But that also doesn't really explain how you got to have to do all of this training. So the federal regulatory framework helps set that stage. The 1933 Act and the 1934 Act sets forth various requirements that apply to not really our issuer friends, but our underwriter and municipal advisor friends out there. But with the Tower Amendment, it then also applies through those entities to the municipal issuers and borrowers. And it's often we will put these together as anti-fraud rules, as well as making statements generally that you should not make any false or misleading statement or omit to state a material fact in the offering document or related to any security that is being sold or offered. Material fact, and then getting into the details, James will talk about that in the SEC Rule 10b-5 and going forward on the continuing disclosure, both in primary and secondary. Well, like with anything, you have to have, a carrot and a stick, right? With the SEC, it's the regulating body, not only really for the underwriters, in the standpoint from being able to impose penalties, right? That's the carrot and the stick in all of this. Those disclosure requirements are imposed upon governmental issuers and borrowers when the municipal securities are sold through that continuing disclosure agreement or certificate, depending on what it's called. Basically, the underwriter cannot buy those securities if the issuer does not agree to comply with those requirements. Or in the case of a conduit borrower, the borrower agrees to follow those rules, which we will go into more detail. The main aspects of those are annual financial information and material event notices. You're also disclosing on an ongoing basis those material events, which are 16 of them that James will be running through and David will be running through later in this presentation. In the end, it's very important to keep in mind that the anti-fraud rules, this framework, federal statutory framework, is governing not only the primary disclosure, that official statement that goes out there to tell the story, to be able to sell those municipal securities, but as an ongoing basis as well. The disclosure non-compliance needs to be disclosed in the primary offering document on a 5-year look-back basis, as well as going forward in your post-issuance compliance requirements with continuing disclosure under Rule 15C212, which you will hear much more about from David and James. Again, why is this all important? The SEC can impose penalties, and the SEC has taken enforcement action and has taken enforcement action for many years. The turning point, I think, at least in the careers that many of us sitting here have been in, is with some significant enforcement actions in 2013, and then the infamous Municipal Continuing Disclosure Cooperation Initiative, also known as MCDC, which at the time in 2014, which lasted to 2016, it was kind of like when you deal with your kids and you want them to do a voluntary, like, fess up, Hey, what did you do last night? Oh, well, and then you look on the video camera and you see what they did. And you try to get them to voluntarily self-report. That's what MCDC was. It was a voluntary self-reporting, but it was also a big turning point because out of that, and I remember telling David and him telling me, this is a really big deal. This is going to be a game changer. And it was a game changer. That's where we got a lot of these continuing disclosure policies put in place, focused on a lot of underwriters now making sure because of the self-reporting and I believe over $18 million of penalties that were issued at the time, hitting 96% of the market. You got these policies, you got disclosure requirements, as well as focused initiatives trying to make sure disclosure is now accurate and focusing on that.
Chris, let me ask you a question, and this is for the whole group. First of all, I'm glad that my kids are glad because I did not have cameras on them, different day and age. Let's talk a little bit about materiality. I'm going to go off script here a little bit. That is a question that we get quite a bit.
You knew you would.
Give us an example of something that maybe has come up or that we would take a hard look at that we would clearly say is material. And I'll start off the one that always comes up that we really focus on is litigation. If somebody, as they're borrowing money, is undergoing any kind of litigated matter that would be or potentially result in significant financial loss, that would be something you would find us asking an awful lot of questions about. Anything else, James?
On the litigation, so we'll get into this a little bit later as well when we talk about due diligence and some of the work that we do to figure these things out. But of course, issuers are subject to litigation as a part of the daily business. What we're really asking about and thinking about is litigation that might affect financial capacity, specifically related to the bonds being issued. And on materiality, that's just you get into the facts of each situation, and we ask questions to try to determine, is it a relatively minor potential liability? If so, it may require no disclosure at all, or is it something that's much more significant?
And while it was on the other slide, I think we get a lot of questions on what does materiality mean? And it comes up in various aspects of the regulatory framework. We'll have materiality for purposes of primary disclosure in that official statement that goes out. And then when we'll talk about financial obligations and continuing disclosure, which happens after, right, the bonds are issued and goes on until those bonds are paid off. What is material for a financial obligation, for example? And materiality is one of those. You might get different opinions on it, but it's the substantial likelihood that an investor would view the fact as significantly altering the entire facts and circumstances of the information that they're receiving. So things that may be material in an offering document may be a significant climate event, which we'll talk about a little bit later, such as a flood, and how is that going to impact the issuer's ability to repay the bonds. If there is a significant audit, just like litigation, that would impact the ability to repay those bonds or the overall financial health of the particular issuer or conduit borrower.
Excellent.
There we go. So we're back on enforcement. Those enforcement actions continue. They were, they've been going on for a long time, right? They've been going on. And then with MCDC, there's been the post-enforcement actions, the SEC giving people a chance to say, look, we know what the rules are now. So we really are holding you to those rules. And it doesn't matter if you're a small issuer, if you're a large issuer, conduit borrower, or the amount of money that you're actually borrowing. And we have a few examples on the slide, and in Appendix A, we provide even more information about those enforcement actions. But those enforcement actions continue, and it's one of the things that can be imposing liability directly on not just the underwriters or the municipal advisors, but on the issuers themselves, on the the chief financial officer that provided the information or failed to provide that information, to make sure, again, there is not a material omission in the offering document or the disclosure, or something that is a little bit, not right. False projections, for example. So that again is that, stick out there that the SEC is using to keep everybody in line.
I'll just add, I think when you stated earlier, MCDC and the real game changer, I think is part of that in 2014 was the fact that the SEC seemed to really go out of their way to penalize some really small school districts and some really small cities where not that I think anybody before that sort of thought that size of town or size of issuance necessarily allowed for an escape from enforcement or SEC watching. But I think purposely, and the SEC, I think, followed up at that time and said, no issuer is too small for us to come and find fault with your continuing disclosure or your primary disclosure. So I think that was a real significant statement at that time by the SEC.
Yeah, and ultimately it's to protect the market and the system that has been created, and those security laws that were mentioned apply to corporate public entities, and certain aspects apply to the municipal securities market, to make sure that the system is still one that you can honor and trust for the investors without going through all of the requirements that you have to do on the corporate side. So even if it's small and you're borrowing $2 million, you have to make sure that you're following those rules.
I think that's a great point and well stated when you use the word system, because what the SEC is really concerned about is making sure the market, right, is functioning appropriately so that investors have all the necessary information to invest in small town, big town, whatever they may be looking at for their investments.
I think to keep us on track, what's our next slide, Jennifer? Guidance on public statement. Again, another reason why we're here, right? And the reason for the ongoing training is new things come up, right? We get new guidance that comes down. This one happens to be from 2020, but applies going forward. And it's very important to keep in mind. I was working with a CFO at a county hospital, and she was saying, we are having the best year ever. It's the best year ever. I know it's the best year ever. She had a bet with her auditor that it's going to be the best year ever. And he said, I don't know, wait, I got to do all the adjustments to Medicare and Medicaid and all the reimbursements. It might be, I don't know. She was talking to me about that and to him about that. She was not out there putting it on Instagram or Facebook or their website that this is the best year ever. And that's a little bit of an exaggeration, but what it shows is that the guidance that is coming out is not saying that information to investors is only in that official statement document or is only in the postings that you put on Emma, which James will be talking about later and Jennifer will be talking about later. But it can be for issuers, especially public entities. You're providing information out there all the time. You're at public meetings, you have websites, you have Facebook, and all of that information and those systems of getting that information out, if it's reasonably expected to reach investors, you have to be careful that that information is also accurate and is not misleading and the anti-fraud provisions of the securities law framework that we were talking about apply to those things. Something that you might not really keep in mind when you're having your best year ever and saying that out in public, that it's the best year ever, which, by the way, she won the bet because they did have the best year ever. And that was, substantiated with her audit, but, but that's also another reason why we have this training. Very quickly, we look to, as mentioned before, we do look to the public company trends that are happening because it does, the SEC does go back and kind of impute those onto municipal securities. The big one is cybersecurity. If you've done an offering lately, you get questions from us, questions from the underwriter, questions from the EMA about cybersecurity. It's a very important topic right now, and being able to disclose those. Climate related, not so much, in Iowa, it's about if there's a flood or a derecho, what is impacting the specific issuer ability to repay or overall financial health. But those climate related disclosures are ones that, change with the political tide a little bit, as noted in our slide there. But the important things to remember from those aspects are watch the buzzwords that you're using. You have to look at and be consistent with the information. And as James is going to talk about, when you have questions, you might want to ask your disclosure counsel about whether you need to disclose those aspects, which I think that's a segue over to
there you
you.
go.
There you go. Yeah.
Yes. We'll spend a few minutes on the pure disclosure side as to what we do, talk about the due diligence process, and then we have a few kind of scenarios to walk through as well. So background, we've talked about this before, won't spend much time, but obviously a couple different roles you'll see us in and different folks at Dorsey in. Bond counsel is really focused on state law and federal tax law and making sure the process to issue the bonds is done correctly, and then they give an opinion. We'll give an opinion at the end of the day for that aspect. The disclosure counsel is really focused on the things we're talking about today with the securities regulations, the primary disclosure, which is the official statement, or you'll see in the slides, OS, that's the OS. And then the secondary disclosure is the continuing disclosure that you'll do after the bond issue closes. Again, on the primary disclosure in the offering document, or OS, it's important to think about the type of bonds being issued, and that drives the disclosure. So things are different if it's a general obligation deal versus an electric utility deal or a sales tax deal. So we'll ask different questions, and the offering document will have different sections depending on what the revenue stream is to repay those bonds. We've talked about materiality, so we can kind of move through that one. And let's jump into an example. So it's April 9. An issuer wants to get ready to go to the market and issue debt to fund some needs in the community. However, the FY25 audit is not yet complete. So let's talk about what does that mean? What do we do? And this is really on the primary disclosure side to sell those bonds. Turn it over to my colleagues.
Well, I'll start. I guess I think the first part of the analysis is how old is the most recent audit. Obviously, usually things are trailing because of continuing disclosure by about a year. It is, but more and more, I think you start to get, outside a year, which we're certainly starting to see more and more of, especially if the state auditor's office is involved in doing your audits. And then you start to maybe see things get out closer to 2 years since you've had audited financial information. And for a minute, I'm going to set aside those entities that aren't required to have audited information. We'll just for now, in this scenario, consider that you're required to have an audit by state law. And so it does start to get difficult. I think on this point, a couple things. Number one, you have to remember when you're in the market, investors aren't just looking at city X or Y as to where they're going to put their money to use, right? They're looking, now the market is the whole muni market across the country, but then also obviously all kinds of other investments that anybody could be putting their money to work with. And so the further you get away from the date that you're issuing to having updated, solid audited financial information, the more disconcerting it gets for all of us. Especially, again, we're trying to describe materiality, and, without an up-to-date audit, you just start to get concerned about what you may be missing that could be material because you don't have an up-to-date audit. There are workarounds. I don't know if you want to talk about those that we've started to use, and some of those are okay. But I don't think anybody in the industry at any level would necessarily say they're great. I don't know if you want to talk about budgets and some of those other things.
Yeah, and the rating agency, if it's being rated, may say, well, I need that information
Right.
to be able to determine what the rating is. And also, kind of my CFO who was having the best year ever, and she turned out to be right, but you have to be able to substantiate that in the document and be able to provide correct and not misleading information. And without having that audit, that's pretty difficult to do. Some of the workarounds, if you're using, some internally prepared information, knowing it's going to come at some point before we price might be an option, but we're waiting. We have some where we're just waiting.
Yeah, and I think it goes back to what we're telling investors in the risks and the concerns, that if something significant has happened since that last audit, so you'll get a lot of questions from us and the other professionals on the deal, just making sure, is there anything that we expect this new audit to show when it is available? If so, we better discuss that now. One of the interim steps that we'll use is the annual financial report filed with the state. Again, that's public information. Investors could, if they chose to, go find that perhaps and look at it. So if we have sort of a gap, we'll use that. But it's important that that's accurate, of course, but it's not as good as having a fairly recent audit. So, all right, thanks. Let's talk about the due diligence process and why we do it, other than that we really enjoy it. It's one of the things that bond attorneys think is a lot of fun. But it helps us to answer those questions about what should that offering document include. And so you'll get a very nice lengthy questionnaire. We call that the DDQ, but it will ask for documents. It'll ask a lot of questions. It might ask them in a couple different ways. The goal with all of it is try to identify things we need to talk about. Perhaps things that need to go in the official statement, perhaps not. We'll generally also have a diligence call to walk through that questionnaire. The group can ask questions and just make sure that things that are covered for the security side are covered. Now, that DDQ also includes tax-related items that in the bond counsel role are important. We won't cover that right now. But again, the diligence questionnaire and the diligence call is a significant and very important part of this puzzle to get to offering the bonds through the official statement.
If I could just add, so I always think of due diligence as the basis to determine materiality. But again, going back to the concept of 10b-5, and what we have to disclose, it's not just material items, it's that we have to make sure we're not omitting to state a material fact. And so I always think of due diligence processes. The goal for that is materiality, but most importantly, I always view that as the fact finding to make sure we're not omitting to say something. And that's why we ask so many questions. It's so detailed, and we ask them sometimes in 3 or 4 different ways. It's to always make sure that the provider of the information, we're jogging their memory to make sure we're understanding and knowing of all the information, so that we can vet and determine, is it material? Do we need to speak about this? And we don't just omit something, but it's because we just didn't know about it.
And the underwriter is often involved in this process as well, because the underwriter has the responsibility under the regulatory framework that we were talking about to make sure that they conduct their own due diligence. So a lot of times the underwriter will be on there as well. It makes it a little bit, more streamlined if we try, but you had a scenario about a cyber.
Oh, yes, let's
cyber
say that there's a cyber
Cyber-
incident.
Cyber incident.
And it has happened in other places in some significant manners with closings and sending bond proceeds to the wrong place. But what should a city keep in mind relative to both if they're in the market on a bond issue, or if they're not and something happens, both with respect to their, legal requirements and things they could do?
It's one of the cyber security insurance, that type of information is one of those topics that the SEC wants to see in disclosure, in primary disclosure, and also informing if has been any attacks in the past. And a lot of this goes to, again, the financial viability of the entity, whether you're talking about a healthcare or municipal or for a city from that standpoint. But definitely part of our normal disclosure requests and needing it to be in the primary offering. Attacks.
Well, I guess this is one of those things that you need to describe your cybersecurity insurance and so on and so forth. Obviously, we don't. You have to be careful not to give too much information to the cyber attackers so that it aids them. So this is sort of one of those areas. It's a little bit of back and forth. As to a cyber attack, I think the most important thing is to give a lot of consideration as to when it occurs, if it's not covered by insurance. Not only if you're in a primary disclosure situation, but a continuing disclosure or other, in the underwriting period concepts that you've really got to give some consideration to. Do you have to disclose? And nobody wants to. Sort of feels maybe embarrassing, although I think the hackers have gotten pretty darn sophisticated. So, but it's one of those things that, if it rises to the level of materiality, you've got to talk about it.
And we'll get to the listed events here on the secondary disclosure side. But a cyber incident is not one of the listed events. So then you're into the world of voluntary disclosure on the continuing disclosure. And that's, again, having the discussion about what's going on, how much debt do you have outstanding, do you plan to issue in the near future? What's the impact of the significance of this cyber incident? So all discussion points that we would want to be having. So next on continuing disclosure, let's dig into that a little bit more. This is when the bond issue is closed and it's months or maybe years down the road. And this is the Rule 15C212 concept in your continuing disclosure certificate. There are two categories. There's the annual financial information, which are the audits or types of operating data in the official statement that get updated and disclosed on the Emma website annually. And then we'll spend a little more time on what the listed events or material events and those 16 items those are more real-time type of items. If they happen, you'll want to be having discussions with your outside professionals to talk about, is this a listed event? If it is, what's the timing for posting notice of that on the Emma website? And generally, we want that within 10 business days. If we quickly go through, we won't go through all of these, but some are pretty obvious, right? If you're having defaults or payment issues, the market needs to know about that. If you have an IRS audit that questions the tax status of the bonds, rating change, Dave will talk more about 15, which is a relatively new item on financial obligations. But these are the types of things that you have to be generally aware of. And if they happen, start having discussions with your external professionals about, do we need to do something? So the next one is a scenario. The city has cash on hand, outstanding bonds are subject to an early redemption or early call, and the city chooses to do that. So what would they keep in mind relative to continuing disclosure?
So I think the first issue is, again, to look at those listed events and make the determination, is it something for which you're required to report? You'll notice in those events, some are deemed a material just by the language. Some actually do allow for a materiality qualifier. So number two, you see there with regard to non-payment related defaults, the language is if material. You see all those various events where, along with determining whether they occurred, there is the ability or the aspect of them determining whether it's actually material.
So on this one, it's 8, right? It's bond calls.
Right.
Material. I've
Right.
never had a non-material bond call, but I don't know, maybe
The
there
practice is generally to file the notice.
I think that's right. I would actually say that it gets a little worrisome because of a listed event to then go to materiality. I think the industry has started to default or has defaulted to, well, if it's an enlisted defense or a listed event, we're not going to really dig too deep into materiality unless it's so small. It doesn't matter. But I think usually you're going to find if it's a listed event, you're just going to deem it as material and you're going to disclose it.
So we paid off some bonds and forgot to file the notice. And it's now 30 days later. So is it okay? I just not gonna file it? Is that, what would you do?
You know, you could file it and it's late, but then on the next bond issue, when you're going through your primary offering, that would get discovered and then of course disclosed as part of the offering document on your next. So as long as you're then disclosing it properly going forward, it's not a significant issue. Next, I think we have another scenario, and this is another one of the listed event ones. A city or issuer receives notice of a change in its credit rating. What about continuing disclosure on that aspect? And sometimes we understand notices don't arrive, rating change happens without the issuer knowing about it. But in this case, we'll say an email is received, and so.
Rating.
You want me to take that one? So I think if you look at event number 11, and this is a bit of a trap, rating change. So I think, and obviously there's no materiality qualifier there. So definitely you have to disclose it. The trap here, I think, is if you get a ratings upgrade, it does need to be disclosed. It's positive. We think of these events usually, or they're drafted in such a manner that they seem to be if a negative event happens. And so I think that's why an upgrade is sort of not intuitive that you'd be providing notice of an upgrade, but nonetheless, the rule requires that you do it. I forget the second. There were other parts of that question.
Yeah, it was kind of the upgrade.
Yeah.
That you covered that. Yeah. Another scenario about defeasance of city debt. So the bonds aren't yet subject to redemption, but the market conditions maybe are favorable or the issuer has other cash on hand to, in effect, a legal defeasance to set aside money pursuant to the bond documents to retire that debt when it can be called. And what about when that takes place?
Yeah, so let me first tackle what a defeasance is. So basically it's when money is secured, cash, or usually a defeasance would involve escrowing money, having an escrow agreement. The money can only be used to pay off those bonds when they are actually able to be redeemed. Material event 9 does call for disclosure of defeasances. Again, I think it's probably sort of it's a positive event. Usually you're paying off debt. And so it's another one of those, I'll call it a positive listed event. It clearly is one that, again, it's oftentimes just forgotten, right?
It's important to the investor though, because the investor, the one holding that bond, knows that it's going to be paid because the money's sitting aside legally. It's over here, right? So So now those bonds could even trade at a different rate.
Right.
So it's an important event, but yes, one that gets forgotten from time to time, for which you could then do a failure to file notice and then file the notice.
And then, of course, disclose it on your next.
There you
bond issue.
go, there you go.
Um,
All about being truthful and accurate, and a foot fault you can fix.
All right, back over, Dave on.
All right, let's talk a minute about events that have been added, 15 and 16. These were added to the listed events in 2019. Are we already 7 years out? So you can see there, we're dealing here with prior, I guess, before these events, there was a lot of recognition that you could have a pretty significant negative financial event or take on pretty significant financial indebtedness that may not have been covered prior to these events being added that weren't listed. And so events 15 and 16 were added in 2019. You can see a financial obligation is a debt or debt-like obligation. This is where we have a lot of discussion, sometimes where we're asked questions, probably occasionally differing views on whether something is or is not really a debt obligation. And so, and then obviously subject to materiality. So I think probably usually the analysis will always err towards thinking of different instruments, contracts, agreements as being debt. Again, because that's the conservative approach. I think probably in this area, we have a lot more discussion internally about, is it really material? So if you go out and enter into a contract for a copy machine, right? Is that a debt obligation? If you're paying for it over a period of several fiscal years, yes, it is a debt obligation. Are you expected to disclose that? Well, thankfully, we can rely on, is it material? And the answer, I think, would be no. And so that's why you don't have to necessarily pay attention to every single little contract you're entering into that may cross over fiscal years. But I think it is important to always keep in mind, if you are entering into even something that is not a loan agreement or something that looks like or you'd think of as debt, if you're going to be paying for a period of years and it's a significant amount of money, I'll say $1 million plus, then you ought to be thinking about and giving us a call, and we should all, be talking about, hey, that is something that we think you have to disclose.
Probably a good time we could maybe jump ahead of 16 and hopefully don't have to worry about that much with our clients and issuers about defaults. But if we're talking about the financial obligation, here are a couple of potential examples. So let's cover first state revolving fund loan. Maybe that one's.
So you already have debt outstanding for which you have a continuing disclosure certificate or agreement. You have an undertaking already that you have to disclose any financial obligations, right? So now you're entering into an SRF loan.
Yep.
So SRF obviously is not a market security for purposes of having to do an official statement,
Yep.
et cetera. So why do I have to disclose it to anybody? I'm entering into a new loan. That's fine. Why do I need to disclose it to anybody? And do I have to disclose it to anybody?
Well, you do.
Yes.
And
You may.
you may.
You may.
And the concept is the investors in your other debt want to know if you're entering into a more significant obligation. So if you have existing, water revenue debt outstanding, the investors would want to know that, oh, by the way, you're borrowing more with the same source of repayment.
So just like any lender, if you're going out for a bank loan and they want to know if you're going to go borrow money in the future, It all goes to the overall credit and health of the issuer, and investors want to know about that. I want to know about it in more real time than waiting for the audit, because it'll be in the audit,
Yeah.
right? It'll be in the audit, but they want to know within the 10 days that you're required to post it.
What about the other concept that we've had a lot of internal discussion about on development agreements?
Can I go back to state revolving fund for a minute?
No.
I suppose.
Two things on that, and the reason we say may is because still has to be material, right? It's a financial obligation, but may not be material. I think the reason I point that out is because P and D loans, that's where 90% of the time, those are not going to be a material amount. We do occasionally those see P and D loans that are several $1,000,000. And I think we would say that that falls into the category, yes, it's a financial obligation, and yes, if it's material size, that then a P and D loan would also need to be disclosed. So I'll let you tackle tax increment because I know it's one of your favorite subjects.
Generally speaking, you have to go through the same analysis of whether it's material or not. I think from the standpoint, we've determined that the rebate agreements do trigger the financial obligation analysis, and then you look to whether or not, again, the amount is material. And that materiality is going to differ based upon, if you're a small city, large county, it's just going to depend. But while the definition of a financial obligation is different under the rule than it is necessarily under the state law, that is one that we have routinely, and I think it's fairly typical now that those are being disclosed if material. Again, if the amount is one that is going to be significant. Considerations. We have to leave a little time for Jennifer to
Yeah.
talk about policies
Yeah,
and
we'll-
procedures,
We'll
right?
keep moving along here. So you should definitely, within your policies, adopt that you've adopted for your disclosure policies, reflect the amended rule. I think by now, most people have done that. They've probably issued since 2019. And so events 15 and 16 have been added. I don't know that I'll go any more into that.
So we've heard a lot about, gosh, scary stuff. We need to make sure that we get these primary offerings taken care of and that we're honoring our ongoing disclosure obligations. And what's a good way to do that? Well, have a policy and procedure in place to kind of put a framework and some structure around those needs. Within the policy, and if you've got one from Dorsey, it's going to cover three main buckets. What you do in a primary offering, that's when you're first taking those bonds to market. What do you do when the bonds are still outstanding, but you've closed the deal? And then what do you do about training? The last piece on this slide references Emma, and some folks are more familiar with it than others, but in the appendix, there's a number of slides that can help demystify what Emma is all about. And if you don't regularly check your own issuers' filings, I would encourage you to do so. You can see kind of the types of information that you can find, and that's only just a snapshot of one example, but I would take a look at that at the in the appendix. So when we're talking about that primary offering, getting those bonds initially out to market, there's usually some working group or finance team calls and schedules. So the person at the issuer or the city in this example would be who's named as a disclosure officer in that continuing disclosure policy. And that person is going to be heavily involved in preparing the official statement, working through the Appendix A information with your financial professional, and oftentimes being the one who gets the document first to review it, and then also as they near getting that official statement approved, they would be the one providing some sign off. This next area kind of talks about, and we've touched on it already, but that intersection between primary and secondary disclosure. So with the primary offering, you give your basically 5-year report card as to how you've done, if you've got pre-existing continuing disclosure obligations, and have those obligations been met. So some things to definitely keep in mind, that the issuer is the one ultimately responsible for getting these pieces filed with Emma, and it has to be in a searchable format. Some issuers will have something called a dissemination agent, and that's when you contract with usually a banker to provide those filings on Emma for you on that annual basis, and then your material events. We've talked a little bit about who's primarily responsible. We've got a disclosure officer who's looking at that continuing disclosure compliance and making sure that those annual filings are done, material event notices are filed, and should you undertake any voluntary filings, that those are also addressed as well. Chris talked about public statements and the importance of being careful and mindful about making those. When you take a bond to market and you have a new continuing disclosure certificate, make sure you understand it. Read it, go over it with your bond counsel or disclosure counsel. If you've got a financial professional helping you with your continuing disclosure obligations with those Emma filings, you will work very closely with that professional as well. In order to make sure that you are meeting those requirements, the policies that Dorsey usually provides and shares with clients, we have a couple tracking tables in the end, which are optional, but we would strongly encourage you to use and track what you've been filing, so you can take a list of all of the bonds that you have outstanding that are subject to a continuing disclosure certificate. And then you can also have a breakdown of a list of what are those operating and financial data tables. Usually an audit is required plus some additional information. That disclosure officer will also be making sure that there's some structure to the preparation of those annual filings. And so by working with your dissemination agent, they'll have kind of a framework by which the information can be gathered and collated to be presented and filed. There's the listed events, and I know we've talked about them and we've seen slides of them a few times, but those 16 items are really important, because if one of those things happens, it's going to most likely be in the city's knowledge first. And so all of the people, Dorsey, your financial professionals, they can help you, but only if you notify and kind of raise your hand to say, hey, we've got this going on. So that's important as well. This next slide talks a little bit about audits. We've talked about sometimes the difficulty in getting them when we want to take something to primary market, but then it also comes back into play when those annual filings are due. So if you've got an audit that is due to be filed, but the audit is not complete, usually what we would want you to do is to file a failure to file, which just indicates that you don't have it ready yet, but we expect it to be, and then you can file some unaudited information like the AFR that James talked about earlier. Another key piece to the policy and procedure is to make sure that you're following training. And by watching and listening to this webinar today, that would satisfy your annual training. We would also encourage, if you've got staff changes and you've got somebody new coming in to work on disclosure related items with you on your team, that you would conduct some as needed training there. And then for your city councils, your board of supervisors, your hospital boards, we would recommend that you do some training with that larger body every other year. That would also be beneficial as part of this continuing disclosure policy and procedure. Throw it back to Dave to kind of wrap us up.
So let me, a point that I thought of. So in conclusion with policies, I think as with all policies, make sure you have them, make sure you follow them, make sure you, keep them up to date. The SEC is keen on post-issuance compliance as much as, primary compliance. I would urge all of you, I think we always urge everyone to strongly consider hiring a dissemination agent because there can be a significant or there is turnover. Most folks for our issuers may not have staff that is in place for long periods of time. So there's a lot of benefit to the continuity for your dissemination to hire an independent third party to handle that for you. If you do that, though, I would strongly urge you to every once in a while check your own Emma website. If nothing more, we have seen filings made to the wrong website of certain issuers. And I think it's just a good, healthy thing to do. With that, one point I really want to make that we really didn't touch on. If you look at the listed events, it's 10 business days from which that event occurs. Audits are maybe the great example that we run into a fair amount. I would say rebate agreements, so on and so forth. When does that 10 business days begin to run? And so audits are a great example. It may be very unclear as to when you receive the audit from your accountants. Maybe it's an email, maybe the email's not recognized, what have you. So we strongly urge everybody actually adopt or receive and have your governing body adopt your audit. That sets the date by which we can then say, oh, you're not late because you didn't actually approve your audit. Same thing with rebate agreements, development agreements, any kind of contractual situation that might be a financial obligation. Have the you folks should sign it last. Obviously, development agreements go out. It may be days, weeks, months before sometimes those get consummated. If the city signs it first, there's could be some real confusion. Well, when did it get signed by the counterparty? When actually does the 10 business days start? So on all those types of things, we would urge folks have the city be the second signer, so that date that it's signed by the city can be the commencement of the 10 business days. We didn't talk much about that, but that is something we've run into a fair amount.
Did you get any questions?
No, and
emailed to us?
I think our time, if you have questions, submit them and we'll follow up separately, of course. But I think with that, we've run through the hour. Thanks everyone for joining us and have a good rest of your day.